number 43, matter of St. Lawrence County versus City of Ogdensburg.
I'd like to reserve 2 minutes for rebuttal, please.
You have 2 minutes.
Good afternoon, Your Honors. I'm Alan Pierce of Hancock Estherbrook, and along with St. Lawrence County Attorney Stephen Button, we represent the appellants here. We're here today because in 2021, the City of Ogdensburg passed local law number 2 unilaterally, requiring the county to enforce the collection of unpaid city real property taxes and to make whole the City of Ogdensburg for those uncollected city real property taxes.
Why couldn't they do that?
They can't, Your Honor.
Why not?
Because, first of all, there's no authority for it in the real property tax law, and it impairs the powers of the county in violation of the state constitution and the municipal home rule law.
If they hadn't opted out in '94, what would have happened?
If they had not opted out, they'd be governed by Article 11.
I mean, would you be collecting city taxes under this scheme then, if they hadn't opted out in '94?
Not necessarily, no, Your Honor. They would then have been subject to an 1150 agreement, which is what we say they're now subject to.
Would they mandatorily have been subject to an 1150 agreement had they never opted out at all?
I believe so, Your Honor.
Well, what happened in other counties where cities didn't opt out? Do you know?
Not for certain. What we know and is in the record are some agreements between 2 cities and 2 counties.
But are those cities that opted out and then wanted to go back?
I'm not 100% sure of that. I don't believe so. Your
What's the purpose of opting out then?
Honor. The purpose of opting out of Article 11 back in 1994 was so that the city could continue to do their own collection
Right.
of city taxes.
Until they decided, arguably, they didn't want to.
Right, which was 2021. And so what the appellate division majority here completely missed, that the dissent seized on, was that as part of local law number 2, they actually repealed their opting out
Right.
law from 1994. So now they're in Article 11, and their method as a city for having the county do the enforcement and make whole the city on real property taxes is
Did
1150.
the legislation provide that once you opt out, you're forever forbidden from going backward?
Not that I'm aware of, Your Honor, and that's why we say 1150 was put into Article 11, we believe by the legislature, so that it would fit this situation where a city like Ogdensburg opted out when they had the chance, timely opted out in 93, 94, but later changed their mind and no longer want to do it themselves.
There seems to,
There you go. Go ahead.
there seems to be a tension in my mind between 1106, which provides that you can opt back in by amending the charter from time to time or something like that, and 1150, which only speaks in permissive terms about the agreements. So under this scheme, it seems as if what happened here is an imaginable consequence of the way these laws are written. You could have someone opt back in and then not do an agreement, and on their face at least, it seems to me none of these RPTL provisions are violated.
Well, we think that the provision here that because the city has opted back in, well, they've repealed their opt-out, so essentially they're back in,
Yeah.
is 1150. And they work together perfectly to allow an
But
agreement.
1150 only says you may enter into an agreement.
Yes.
Which seems to imply that you may not enter into an agreement.
And the
as well.
county here did not.
They
They
did.
asked us to.
So then what happens when you're at impasse like that? They can never, ever
Well, I think they
opt back
have,
in, if we'll call it that?
they would have certain remedies. One would be to make the deal sweet enough to get the county to do an 1150 agreement. Another might be to get the legislature to act. We pointed out in our brief RPTL 999, where the legislature actually directed the situation between the city of Geneva and Ontario County back in the 60s Exactly how that came about, I don't know, but
That's way before,
Yeah.
it's before Article 11.
yeah, and so, I mean, wouldn't you say it's you can disagree with me if you'd like, a fair interpretation of the legislative history or intent behind Article 11 was the state decided there was too much disparity among counties in how taxes were being collected. Article 11 provided a uniform way that the legislature thought would be a good thing, but they allowed cities, towns, whatever, to opt out if they wanted to. They had to meet some criteria, but the idea was they would kind of get tired of opting out and be allowed to opt back into the comprehensive uniform system. Is that fair?
Yes, and that, Ogdensburg got tired of collecting, said
And
it's,
so
you
that
know,
kind of
operational.
comports, and they're falling into the uniform scheme that's sort of in Article 11, is what the legislature had hoped for when it passed it. And then, so my next question then is, how does 1150 work for you if Ogdensburg is no longer a tax district?
Well, that's putting, that's the ultimate issue, because the only basis they assert for what they did, a unilateral amendment of the city charter, is the definition of tax district in section 1102-6B.
Well, so that goes back kind of to Judge Garcia's initial question, which is, suppose they hadn't opted out in the first place or hadn't qualified for the opt-out, would they then have been a tax district?
I believe they would be a tax district.
If they failed to opt out and they fell under Article 11, initially, they would still have been a tax district.
I believe so, Your Honor.
Why?
Well, because they would be collecting taxes. They would be collecting their own taxes.
If they
You know,
fell
the
under the
legislature
provisions of
created.
Article 11, wouldn't the county have been collecting their taxes? Isn't that the whole purpose of Article 11?
I don't believe so, Your Honor.
Okay.
And here, they're relying on 1102-6B for the definition of tax district. That's a substantive, that's a procedural definition, and like this court's decision in Town of Arundequoit.
Determines whether they're a tax district or not.
Yes. And in fact, here,
No, that's the question. Who determines? You said they changed the charter,
Yes.
and you suggest they can't do that.
They can't,
Who can make that determination?
well, they can do an agreement, or they can go to the legislature, like City of Geneva and County of Ontario did.
That defines whether or not they're a tax district?
They're a tax district because the definition of tax district there is that a city, a city other than a city for which the county enforces delinquent taxes. So here, the city would be a tax district because the county is not
Okay, but
enforcing.
under local law 2, they relinquished their tax, their tax enforcement scheme. They said, heretofore, this will all be done by the county. So if you're using the functional definition, which seems to be implied in 1102, once they relinquish those responsibilities, then it would seem, and this is the holding, I think, of the majority at the appellate division, that they were no longer a tax district. Isn't that what they held?
It is what they held. And interestingly enough, the city in its brief says the majority was wrong in stating and relying on that they were wrong. Because this comes back to the fact that they did it unilaterally by city charter amendment.
What about the powers argument?
Yes, the powers argument, the city here and this court adopts the dissent's definition of impair as to weaken. And they say, well, the dissent didn't factor in or look at impair the power. What's the power? And they use some dictionary definitions. And I say the Black's Law Dictionary is a better definition for purposes of this case and the Constitution and the municipal home rule law. And power in that circumstance includes what you can do and what you don't have to do. And here, the county didn't have to collect the city's delinquent real property taxes before this unilateral charter amendment, but now, according to the appellate division majority, they do have to do that. That is weakening the power. And the other powers here, we know county law provisions, 215 and 204, say that the Board of Supervisors or legislators shall have the general care and control of the corporate, real, and personal property. And County Law 204 says the county board has the power to establish positions of employment. The record here shows that once this law passed and was upheld by the trial court as part of the papers in the original motions, the county immediately had to go, when the law was passed, and try to find an office in the city of Ogdensburg to do this. They had to,
But why aren't they right, that all it means is that you're now subject to Article 11? I mean, how is that, that's what the legislature anticipated anyway.
and the city is subject to Article 11 now because they've repealed their opting out, and so their option is 1150.
But counsel, if they would have opted in 94, wouldn't you have had to do all the things you just talked about, open an office? And so was the 94, that 93, 94 legislation unconstitutional also, to allow an opt-out and opt-in? I mean, would you have to change the way you did things if they had opted in 94?
Well, I go back to my answer to the question. I don't believe the county would be then required, even back then, to have done what this local law has required them to do.
In what specific sense do you mean that?
They would not have been required to enforce delinquent, unpaid city real property taxes and make the city whole.
It doesn't seem like an opt-in, opt-out. It seems like an opt-out or maybe you opt-in.
Well, I think one of the, what it comes down to here under the RPTL, in many ways, is that the appellate division majority, in its opinion at least, ignores the fact that local law 2 repealed the old opting out. It's a central focus of the dissent. Certainly the majority
And
knew it.
explain that to me. I don't really understand that point very well. What's the difference if they repealed it or they just said, now we're opting in?
Well, a main focus of the majority opinion was the fact that they did opt out.
Right?
And the majority said
I understand that argument. I'm not so sure I understand the dissent's argument.
about that
About
they repealed
They
it.
did this by repealing their opt-in. I mean, it's just the mechanism they used that's deficient here, or substantively they couldn't do this? I'm having some trouble with that argument.
Well, Your Honor, by repealing it, I think the dissent makes clear that now they're subject to Article 11, and that the definition of tax district doesn't.
What was the alternative to repealing it that wouldn't have made them subject to Article 11, but opting back in? That's my question, I guess. Is it the mechanism they used, the fact that they repealed it and called it a repeal, or is it just the fact that they tried to opt back in?
Well, the only way they opted back in was by repealing that
But
provision.
was there another way they could have done that that wouldn't have run afoul of your argument and the dissent's view?
I think going to the county and agreeing to an 1150 agreement. I think,
That's the only way to opt in.
well, besides repealing their opt-out, I believe so, Your Honor. So as I said, the city here actually says in their brief to this court that a linchpin of the majority opinion was wrong when they said that the city was statutorily authorized to amend its charter under RPTL 11042. The city says they're wrong. That and the opt-out are the linchpins to the majority opinion. And the majority didn't address the repeal of the opt-out, and the city admits, yes, we did repeal the opt-out, and the majority's wrong to rely on 11042 to allow us to do this by amendment of our city charter. I think between those two admissions by the city, I don't see how they have any authority under the RPTL to do this. And then we have the constitutional problem that they've largely adopted the dissent's position on the constitutional and municipal home rule provision.
Thank you, counsel.
Thank you.
So counsel, is the city a tax district presently?
No, Your Honor, and may it please the court, Nick Cortez from Coughlin and Gearhart on behalf of the city respondents. No, and they're not because of the charter amendments. And just to give the court a little bit of a background to hopefully help to clarify this opt-in, opt-out thing. So prior to the enactment of the current Article 11, the city had enforced their taxes or their delinquent taxes pursuant to unique provisions in the city charter. The city charter included provisions by which the city would collect the county's taxes, the city would make the county whole, and that has nothing to do with the current Article 11 of the RPTL at all. And so the way that we read 1104 is that you can, as of 1993, you could opt out and continue to enforce your unique taxation collection scheme via your charter, or you could repeal that, you could repeal the opt-out because you had to pass a local law in order to opt out first, or you could repeal the opt-out and make yourself subject to the provisions of
And
Article
where
11.
does it provide for this repealing? Because what's the point of the opt-out? Where does it provide for that? Why have a date? Why not just say you can opt out? Can you just opt out and opt in at will?
No, I think that you can you could have opted out in 1993, and when Article 11 was enacted, and then you could opt back in, but I don't believe that you can opt back out
Like
again.
I say, where does the statute say you get to do that?
I believe that is it's a different provision of Article 11, Your Honor, but off the top of my head, I cannot remember what it is. But there is a separate provision of Article 11 that explains the opt-in procedure, which is a repeal of your.
Well, wouldn't that be the crux of the case? If it actually allows for such a procedure, and then the question is, did you follow that procedure?
I think that
I thought their position was there is no such language that allows it. All you can do is try and enter one of these agreements with them. And if you're at an impasse, that you got to do something else.
So if the city makes itself subject to Article 11, which it did, and that's our position. I mean, you can't. In all local laws can be repealed. So if you can pass a local law that does a certain thing based on your statutory authorization to do so, you can repeal that local
But
law.
are you basing that on 1104-2, which says the code or special law may from time to time be amended? Is that the statute you're talking about that lets you opt back in?
No, it's a separate provision of Article 11, Your Honor, and
Is it 1106?
Yes, no, yeah, 1102 is the definitions, 1104 is the opt-in, is the opt-out, and 1106, I do believe, is the provision that allows you to
It talks
repeal.
about repeals
Yes.
of
Yes, Your Honor.
opt-ins without the need for a referendum.
Yes,
and
Your Honor.
various- And it also includes a provision about a transition period when you repeal your opt-out. There has to be a certain amount of time in which if a parcel is subject to both a lien or liens arising out prior to the effective date to the lien, the procedures applicable to the enforcement of the delinquent taxes shall depend on the lien, et cetera, et cetera. Your repeal didn't include a transition period. The way I read it, and correct me if I'm wrong, you just handed the whole thing over to the county and sort of said, we're done with it, you take care of it now. Isn't that right?
I think that's basically the way that it happened, yes, Your Honor.
So is it possible that your repeal was defective under 1106?
I don't believe it was, Your Honor. I believe that it was done effectively. And, it's interesting because the dissent at the appellate division seems to indicate that if we never effectively opted out, that we could do what we did in this situation. Our position is that opting back in and subjecting ourselves to the provisions of Article 11 gives us the benefit of the definition of tax district.
So what is it about your opting back into Article 11 that also, if I understand it correctly, switches the liability for the uncollectible county taxes? Because I take it, you've been compensating the county, you've been bearing the burden of uncollectible county taxes until you opted out.
Yes.
And part of the issue here is now you're asking that they bear them. What is it about, if anything, opting into Article 11 changes that?
Because that touches off that's the first domino in the analysis that knocks over all the other dominoes.
Well, that doesn't really help me.
I understand.
Yeah.
But so let me explain. Opting back into Article 11 gives us the ability to take advantage of the benefit of the definition of tax district. And that says that a city is a tax district unless the county collects.
Right, that's fine, so you're no longer a tax district.
Right, so we're no longer a tax district, which means that by default, the county is now the delinquent tax collection enforcement authority for the city, just as it is presently for all towns in St. Lawrence County and villages as well.
I got that, it's collecting, but what renders it liable for the delinquency of your taxes?
RPTL 936, and that provision which states that.
That's not in Article 11,
That's true, you're right.
so how do we get to there?
So in Article, there's a definition in Article 11 of delinquent tax. And the definition of delinquent tax in Article 11, let me just find it really quick here and I can share it with you. Yes. So the definition of delinquent tax in Article 11 is it defines unpaid taxes as imposed on real property by or on behalf of a municipal corporation relating to any parcel which is included in the return of unpaid delinquent taxes pursuant to RPTL 936 or such other general, special, or local law as may be applicable. So under Article 11, there is a definition that cross-references RPTL Section 936 that defines delinquent taxes as as any tax that's included in a return that's provided to the county as a collection.
So now I've gotten to the point that those taxes are delinquent. How do I find who was responsible for bearing the uncollectible amount?
I'm sorry, Your Honor, I don't really understand your question.
Yeah, I think all you've gotten me to so far is a definition that says the taxes that are delinquent are the taxes that appeared on a tax roll.
Well, those are the delinquent taxes are the taxes that go unpaid. They're not paid
Right.
timely.
So who is responsible for bearing the cost of the ones you can't collect? And is that different whether it's a county tax or an Ogdensburg tax? Where do I find that?
Under the scheme that presently exists, if the city is unable to collect and enforce its own delinquent taxes, the default collector and enforcer is the county under the RPTL, under Article 9 and under various provisions of Article 11 as well. I feel like I'm not answering your question very well, but I'm doing my best because I'm having a little bit of a difficult time understanding it.
Sure. Council said that there were really two changes here. Who's collecting the taxes and who's responsible for the ones that you can't collect, right? The person is gone and you can't get them, right? It used to be the case that as I understood it, up until you opted out, if there were county taxes that couldn't be collected because the person was nowhere and they owed the tax, you made the county whole for that. Your argument, I believe, is that now that you've opted into Article 11, they are now responsible not only for their delinquent taxes that they can't be uncollectible taxes, but for your uncollectible taxes as well. And I'm wondering where's the provision that says that?
So that's the definition in 1102, is we've abrogated our status as a tax district, and because we have abrogated our status as a tax district, the uncollectible taxes have to be collected by someone, and the default in the RPTL is the county. Previously, our collection scheme was based only on our charter. It was not within the scope of Article 11 of the RPTL. It was a unique system that existed prior to the enactment of Article 11.
Can I try this question maybe a little bit differently? Are you saying liability follows collection responsibility, so there's no distinction? So if you have the responsibility to collect, you have the responsibility to make whole?
Yes, yes, Your Honor. As it relates to delinquent tax enforcement, yes. If you are collecting and enforcing delinquent tax, that's one function, yes.
So under the old regime, prior to the opt-in, opt-out, your inability to collect county taxes would trigger a responsibility on your part to make the county whole for the uncollected taxes?
The way that it existed under the charter is that the city was collecting the county's taxes, just timely taxes, and as well making the county whole for uncollected taxes.
liability for making the county whole in your scenario was based on the fact that you were the collecting agency.
Correct, yes, yes, that's exactly right, Your Honor.
And you went for 30 years guaranteeing their delinquent taxes and only now decided to switch it?
Yep.
How does that not impair their powers?
So the county's current argument with respect to impairment of powers relates to the idea that they believe that they have the power to do nothing at all. But when we, and I mean, they took it out of Black's Law Dictionary. I have no doubt that it's in there. That's fine, in a vacuum. But in the present context, we're talking about governmental powers. And governmental powers are those that are vested in local municipalities by the New York State Constitution and by the state legislature. And local, and those powers are affirmative grants of powers to act. And
So his definition that you're preventing them from not doing something that they didn't opt to do is contrary to the definition?
Yes, Your Honor, that's certainly our position. And further, I would argue that under the present circumstances, the county, and for the same reasons that we just got done discussing, the county doesn't have the ability to do nothing under the present circumstances anyway, because they are the collection and enforcement agency for the city by virtue of our charter amendments. And they're also, in reality, right now, the collection and enforcement agency for all villages and all towns in St. Lawrence County.
Counsel, I've heard it said that with great power comes great responsibility, and I at least understand part of the county's argument to be that by giving them this additional power to enforce the tax liabilities, you've created additional responsibilities on their part to modify whatever their enforcement mechanism is, hire more people, start more actions, just do more things than they had to do before. And that's at least partially what I understand their impairment argument to be. Why isn't that an equally valid way of looking at it?
Because the fact that the practical consequence of the charter amendments may cause the county to make certain decisions about staffing, budgeting, et cetera, that doesn't impair their authority to make those decisions in any way. And when we talk about governmental power, we're talking about the authority to do a thing, not what the practical consequence is of this scenario or that.
So if they
No longer
had,
have the authority to saddle you with their bad debt.
What's that? I'm sorry?
No longer have the authority to saddle you with their bad debt.
Yeah,
thank you, Counsel.
you're welcome. Thank you, Your Honors.
Counsel, I'm sorry, just on that last point, my understanding of this case was that it was focused solely at this point in the litigation on collection and responsibility for the city taxes.
It is. It's been acknowledged and admitted throughout here that one aspect of local law 2 is valid, and that is where they said, county, you go collect your own county taxes from city residents. We have no dispute with that. There's case authority for that. We've cited in our briefs.
And the school district issue is not here either, right?
It's not here. It's moot. I think what's really important here is we talk about collection and enforcement is what I think has been at least missed by council so far. The city of Ogdensburg is still collecting taxes. It's only when they get to the point, oh, well, we weren't able to collect, here's our bad tax debt. We weren't able to collect $300,000 of city taxes. Here's our warrant and bill, county. You give us $300,000. It's the enforcement that they handed to us.
Well, how are
They
collecting
kept the
taxes?
collection.
How are they collecting taxes if they're no longer a tax district?
That's a good question, Your Honor, and I don't know the answer because you can't. But that's it. They opted back in based on their charter amendments to some of Article 11, but not all of it. Because if they really opted in, they wouldn't still be doing the collecting. But they are. And
Somewhere in the record, we can see that?
yes, Your Honor, in the local law that's in the record, and I made this, or I pointed this out in our reply brief, that they're doing a have your cake and eat it too argument because they opted in, but they're still doing the collection. It was interesting. This is a topic at the third department. Who's doing the collection? And it's clear the city is doing the collection for 2022. Last I knew, they hadn't actually handed the county the delinquent tax bill and said, okay, give us the money.
Where
What
in
if
the
the court
record-
concluded that, yeah, they can opt back in, and then they're subject to Article 11, and they can't do this part that you're talking about?
They need to come to the county and get an 1150 agreement. And I think there's been a question, what if they'd never opted out? There is no express provision in Article 11 that requires a county to collect city real property taxes, like the provision in the town law that does require a county to handle town tax,
I
real
wanted
property
to ask
tax.
about that. So in all the other towns and villages in the county that are not tax districts, you know, the way this one is defined as a tax district, is the county collecting and enforcing the local taxes? And is your argument, I think I just understood you to say, that's because it's governed by a completely different statutory scheme?
It is. In St. Lawrence County, we have one city, Ogdensburg. We have, I don't know how many towns and a number of villages. By operation of Real Property Tax Law 976, the county is required to do the enforcement of town taxes. For villages, the county is not statutorily required to handle village real property taxes, but St. Lawrence County is doing it. And the problem with this practical argument that the city makes, well, we're the only city, they're doing every other municipality in the county. The problem with that is, first of all, it doesn't give you authority to do what they've done. Second of all, that's not the situation in lots of counties in this state. I looked it up. In fact, Westchester County ought to be very interested in what happens in this case because they have 6 cities. What if 6 cities in the county of Westchester say, okay, Ogdensburg got away with this, we'll do the same thing? I don't know their opt-out, opt-in status.
So
I
is the
don't-
crux of your argument that Ogdensburg simply cannot lose its tax district status? That's not an option that's available to them?
Not in the way they did it here by unilateral city charter amendment with no authority for doing so. The authority that the appellate division majority said gave them that authority to do it, the city says the majority was wrong.
And are you saying they only have given up the delinquent aspect? They're keeping the principal collection?
Absolutely.
It's only when things go bad?
Yeah.
They said, here,
Yeah,
you take it.
they're now handing us their bad debt and saying, give us a check.
Would your argument be the same if you had all of it?
I'm not sure I understand
You
all of
you
it.
were collecting the taxes, even the good, you're collecting the good taxes and the responsibility in whole.
Well,
You seem to have been arguing that they were, you said, having their cake and eating it too, and that did not seem necessarily fair.
right, it's not right. I don't think it would change, if they had unilaterally said, we want you to collect all our city taxes and make us whole for whatever you don't collect for us. I don't think our legal argument would be any different because there's no authority for them to unilaterally impose those obligations on the county. There's none, and it weakens our powers. But here, it's ironic that they're trying to claim, we're back in Article 11, but they're not completely back in Article 11.
Well, It's
I have a
hard to
question.
see who would enter these agreements, given the position you've taken.
But we've shown in the record that City of Binghamton and Broome County have, and I forget the other one that's in the record.
But in 93 and 94, and if you opted in, what happened then, though? Because there must have been authority for the county to do this for a city under that statute. And was 1150 in place at that time?
1150 was, I believe, was part of the original Article 11 adopted by the legislature in 1993.
So under that statute that passed, unless you opted out, you were in, right?
Yes,
And if you were in, it only meant you were in if you could come to an 1150 agreement?
that's the only way a city could pass that obligation on to the county.
But I understand that, you're saying that, but 93, 94, opt in, opt out. If you, opt out or you're in. So a city doesn't opt out, they're in. Now what happens?
Whatever was in place before then, presumably like an agreement between any cities in a particular
But
county.
they have something that's going on their own. They're doing their own collecting and enforcing. Now this law comes out in 93, 94, and they don't opt out. What happens? They want to go under this new law. They have to negotiate an agreement, or they're in?
Well, they're in. And there is, like I said, there is no express provision in Article 11 or Article 9. Article 9 really is with towns. We have this express provision in the town law, or Article 9, excuse me, that says the counties have to enforce and handle real property taxes for towns. There is no such,
I understand that, but I think what I'm trying to get at is the cities, under the statute in 93, 94, they don't opt out. What happens to them? Now they want to go in. They're in. The county's responsible. So how does that work?
but I think that the issue, the county's not responsible, Your Honor. There's no provision that makes the county
So why
responsible.
opt out? I
Yeah,
mean, you're out
what are they
anyway.
getting? What are they getting to stay in or to be in?
I don't know. I don't know why Ogdensburg opted out in 1994 in a timely fashion. I don't know why they
That's a
did.
different question. The question is, suppose they had done nothing, then they automatically under Article 11. What is the consequence of that? What does that statute mean for somebody who didn't do anything, didn't opt out? They're in. What does that mean?
It means they're subject to Article 11 and all of its
And,
provisions.
and how is that different from what they were doing?
I don't believe it is, Your Honor, in this case. The city
They
of
would have
Ogden,
still collected their own taxes. The county would not have taken over their local tax enforcement and collection.
not been required to. They could have agreed to under 1150.
So then why is there an
Yeah,
opt-out
what-
provision? I mean, there's no need to opt out. I mean, you're out unless the county agrees to it.
Perhaps the city, perhaps various cities who did opt out, and there was more than Ogdensburg. I think I may have even, I alluded to the number around 20 or something out of the 62 cities in the state opted out. I'm sure they had their reasons. I don't know what they are. There's no record here of why Ogdensburg opted out. I mean, they've made a record as to why they wanted to repeal that opt-out here because it was a financial and administrative burden to them. They didn't want
The
it.
question isn't really why they opted out. The question is, for the ones who just sat there and therefore were under Article 11, if nothing changed for them, you're reading the whole legislation as if it had no effect.
Well, I don't think so, Your Honor. Then now they're subject to whatever provisions there are in Article 11, such as 1150.
But you told us that even back in the 1960s, a county and a city reached an agreement on their own without the benefit of Article 11.
No, there was legislation in the 60s dealing with the city of Geneva and the county of Ontario. The other ones that are in the record, and I apologize, I mean, I don't have the specific page, but they are in the record where, we put them in the record, the county of Broome, city of Binghamton, and I think the city of Jamestown, and the county
All
it's
right,
in.
so this is becoming clearer, I guess. So you view Article 11 as essentially an all-purpose version of the individual pieces of legislation of the type you were just describing. That is, through 1150, it facilitates the ability to reach agreements they wouldn't have been able to reach with the cities in the first place.
Yes, it sets up a series of provisions, not dealing with ones that are covered elsewhere, like school districts in Article 13 of the RPTL, villages in Article 14, towns in Article 9. So, but there is no, I'm sorry, I keep coming back to the fact, there's no provision anywhere in the RPTL that makes a county responsible for a city's taxes. And I'm assuming the reason for that, I don't know, is that the legislature assumed that if you're that status of a city, you can handle your own real property tax issues. And
Thank
you
you,
should
Counsel.
handle that. Thank you.